You're set.
Good evening, everyone, and welcome to the Town Board Work Session for Tuesday, January 26, 2021. Thank you for your patience. We're a couple minutes late. The first item that we wanted to start with this evening is our discussion of the form-based code and DGEIS, and the Town Board wishes to have a discussion regarding our ability to codify limitations on the unit mix under the form-based code with regard to the number of bedrooms and units that are proposed for the form-based code. So I'll say just a word about that sort of before we get started. So we heard a lot of feedback in our most recent public hearing, as well as comments that we've received from our Board of Education with regard to concerns that the projected unit mix that is in our DGEIS, in our draft generic environmental impact statement, what we studied related to the form-based code may or may not be in fact what we would get in reality. So I wanted to just start by saying that the mix of units, that is studio, 1-bedroom and 2-bedroom units, which is what is proposed in the DGEIS, what is studied in the DGEIS, is informed kind of by two overriding factors. So the first is the desire of the town board to create a type of housing that doesn't exist in our community today. So whereas we have single family homes in our community today, we are trying to create a housing type in our hamlet, studio, 1-bedroom, 2-bedroom, rental apartment units that doesn't exist to meet the demand. And specifically to meet the needs of the community that came out through our comprehensive planning process. So through that planning process, this is what we heard from the residents who participated in that process was something that the community needed to create. The other factor that went into the breakdown that's included in the DGEIS is our expert consultants analysis and understanding of what has happened with other types of transit-oriented development projects that they've been a part of. So they applied their expertise and their knowledge of the market and looked at what have other communities found when they've developed multifamily residential housing close to a train station. Those two factors are how we came up with the housing mix that's in the DGEIS today. So that said, we've heard a lot of feedback and concern from people that we may not get what we've studied, what we've analyzed. And so that's why we want to have this conversation today. Specifically, the concern has come up from our school board and from our community related to the projection in the number of school-age children. So as you change the mix of housing units, the multiplier that you use to calculate the number of school-age children comes up with a different number of children depending on the mix of units that ultimately are built in the hamlet. And this would in turn then impact your enrollment analysis as well as your capacity study. And we've heard some feedback from the school board that they wanted to look at that question. We've also heard from the public, people saying, well, what if instead of getting studio 1-bedroom and 2-bedroom apartments, you get luxury 3-bedroom or 4-bedroom condos? How does that change this dynamic? And so I think it's important to note that the town board takes the perspective that we want to end up with a housing unit mix that is similar to what we've studied in the DGEIS for the reasons that I mentioned at the top. And so this discussion, we've invited our attorney, Nick Ward-Willis, to give us a couple of different options for ways that the town board can, as I said, codify or regulate the unit mix that we get. The other question that Nick is going to speak to us about is with regard to whether a 1-bedroom unit with a den should be treated like a 2-bedroom unit for the purposes of calculating potential school-age children resulting from it. And so those are the two issues that we've asked our attorney, Nick Ward-Willis, to brief the town board on this evening. So I'll turn it over to you, Nick.
Great, thank you, Ivy. I'm going to actually start at the end because that's the simpler one and doesn't require as much discussion. And by the end, I mean, regardless of what you come up with in terms of limitations on bedroom counts, how do you enforce it? How do you make sure that what the town board envisions is actually adhered to when someone doesn't convert something into a bedroom? And the answer to that is already existing in the town code as well as New York State law. So New York State law, the Fire and Building Safety Code, requires that for multifamily buildings, they be inspected every 3 years, and that's actually within the town code. Municipalities also have the ability to reduce that frequency, make it more, increase that frequency, make it more frequent by 1 year, 2 years, or leave it at 3 years. And communities in Westchester have it at various stages: 1 year inspection, 2 year, 3 years. So what happens is the New York State requires that the building inspector of a fire marshal, the fire marshal does an inspection for fire safety purposes, and there's a list of items they need to go in there and look, right? The common ones, smoke detectors, et cetera, as well as other safety hazards. And one of those that would be included, and we spoke with Tom DuPole, who conferred with your fire marshal, Robert Bancroft, that yes, the conversion of bedrooms is something they look for to make sure there are not illegal bedrooms, because there's issues of ingress and egress and fire safety that would need to be examined, and that if they found there was a space illegally converted into a bedroom, that they would cite that as a violation, and that an order to remedy, which in essence means that bedroom has to be removed. So in response to concerns about even if you allow something, people will convert it illegally, there are mechanisms to deal and address with that. And when evaluating zoning codes, when doing secret, you have to assume that people are going to comply with the law, and most people do. And to the extent they don't, there are mechanisms to correct those and catch those deficiencies. So any questions from the town board with respect to that issue in terms of how do you enforce the bedroom restrictions?
Does that hold for condos or just apartments?
It's multifamily units, so condos would not, single family homes do not. So they would be treated differently. And there are the ability to impose not just order to remedy, but also fines and bring them to the justice court to enforce it. So it's a tool that has teeth to be enforced. And the town board can set and increase those fines as well.
So Nick, what qualifies as a conversion to a bedroom? It's like putting a bed in a den. Does that count as converting it to a bedroom?
We would have to have that discussion in more detail with Fire Marshal and Tom, but I believe it would be certainly, yes, the evidence of a closet being constructed, someone living there, the bedroom in the room, evidence of it being habitated by someone in that space, for example, not being a den, but being having attributes of living space. But I'll get you some more information on that as to what things they would look for.
Yeah, there's also the width of the doorway plays a role in that as well. If there's a space that is referred to as a den, the doorway is not sized as similar. It is sized differently than a bedroom door. You cannot fit a standard bedroom door on within the dimensions of a den. That doorway, is much wider. There are often times that we've had applicants, we've had them change the width of the doorways if they are, for example, creating an accessory apartment and reducing the number of bedrooms in the primary dwelling. For example, if it's a 3-bedroom, they're reducing it's in the primary dwelling to a 2-bedroom because they want to give a bedroom to an accessory dwelling. We require them to remove closets and to change entry widths as an indicator of making that change.
So then the next discussion topic is how do you determine what are the options for a municipality in coming up with restrictions on unit counts from a zoning perspective? How do we determine what that mix is? And there's a number of different ways, and Sabrina, please join me in this discussion as well. Municipalities, and we can provide you with examples in Westchester and other counties, have these restrictions already existing that set forth limitations on occupancy, and that's what we're talking about. of the occupied space, how much of that is dedicated to a bedroom. And it could be by limiting the number of bedrooms. You could have the zoning ordinance state that there will only be 1 bedrooms or 2 bedrooms, or it will state that there needs to be a specified ratio, a mix, 80, 20, 70, 30, whatever the case may be, and give that mix. You can also limit it by the number of units or number of bedrooms per square foot of developable area. You can also have maximum space counts, so that you say the maximum size of a unit can be no more than 800 square feet and 1 bedroom. And that would also aid in limiting space being used as a bedroom. So there are a variety of ways that this can be examined by the municipality, and the form-based code as currently drafted would be the vehicle that would be done through. And you now have that data from the DGIS. So the next version of the form-based code would take the data that you've interpreted and received as part of the DGIS study and comments you received from the public, to then now determine what mixture would you like. Do you want to have a required ratio of studio 1 bedrooms or 2 bedrooms? Do you want to have a maximum unit size and restrict it that way? Or do you want to have a ratio of different unit sizes so you have a mixture of apartment sizes? Or do you just want to have a maximum number of bedrooms and units per acre? So there's a couple of different ways this could be looked at.
And they could be hybrided if that's a verb, but there could be a hybrid of different concepts or plans.
They can be, yes. We can come up with it by the total size of the building. If it's a smaller building, maybe you want to have more latitude.
Is there also regulation, and I'm sorry, I think we discussed in the past, regulation as to how many people can live per square foot?
So that's regulated by the New York State Building Code as to the number of occupants and how much space you need to provide by that. But we have looked into, when we're coming up, that's my next research item, is just looking at other codes and coming up with examples for you of limitations on occupancy and building that into your code.
Nick, when it comes to the different mechanisms that you discussed with regard to how you might codify limitations on the mix of units and the number of bedrooms, do you have a point of view on which one, from a legal perspective, is most solid? You know, I'm concerned that if we take a route where we put these kinds of regulations into our code, I want to make sure that whatever we're doing, we're on very sound footing.
Yep, I understand the question, and I think it's trying to find the right mix where you're allowing the developer flexibility to build something that the market is going to serve the needs of the community and the marketplace, but also is enforceable. Having the ratio and putting into that a maximum unit size gives you something that is enforceable and can be reviewed by the building department. It gets reviewed during the planning stage. And in my mind, that's the cleanest and the easiest way, and is also enforceable. And
so what happens in the case when a developer says, I don't want that? You know, that's all well and good, but I want to build 3-bedroom units. What is how would they accomplish that, or could they?
They could. Their recourse would be to go to the zoning board to try to justify a area variance and demonstrate that they would meet those criteria. However, I think based upon, and I say they could, just meaning that they have the ability to at least apply for it, doesn't mean I don't wish to imply that they would be successful. I'm just saying that they have that ability. The law requires it. The law requires that there be a relief valve for those who think that they've been unduly burdened or impacted, that they could apply for an area variance. And what we could also do is come up with other mechanisms that might make that a bit more difficult. But with the area variance, they would have to go through and satisfy the criteria, and the DGEIS and the FEIS in your finding statement would make that difficult for them to do so.
Right. So all of, yeah, I want to add to that. It would be very, very onerous on that applicant to obtain an area variance because of all of the work we're doing right now. And,
Right.
You know, the analysis that's being done, the additional analysis to comply with public comments and put together the FGEIS, and ultimately your findings will set forth the rationale as to why you want to restrict to studio 1 and 2 bedroom units. which will be very, very difficult for an applicant coming in under the form-based code to apply for an area variance.
But they would come in and purchase a property after they already know of the zoning, after it's already been studied, and then subsequently ask for something they know they can't get at the time of purchase. Seems a little bit extreme.
Right. So if we look at the criteria required to get an area variance, there's 5 factors. Whether an undesirable change will be produced in the character of a neighborhood or a detriment to nearby properties. The answer would be yes, because you've looked at that in the DGIS and you would have examined and come up with the character of a neighborhood and the mix you're trying to take and the purpose of this housing. 2, whether the benefits sought by the applicant can be achieved by some other method feasible for the applicant to pursue other than an area variance. So here is the construction of a multifamily dwelling unit. They could do so, it's just they want the 3rd bedroom, but they could still construct a multifamily dwelling unit with 1 bedrooms or 1 bedrooms and studios. 3rd, whether the variance is substantial. It's a factor. Certainly 3 is more than 2. Whether requested variance would have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. Again, as Serena said, you're going to be examining that during the DGIS and your finding statement, and there would be findings in there that would discuss why there would be those impacts. And also whether the alleged difficulty was self-created. And here that would weigh against them because they would have acquired property knowing what the existing code was, knowing that there was a discussion, knowing there was a DGEIS for the form-based code. And so that would weigh against them also. So it's a burden.
And I want to point out in your code today, particularly when it comes to incentives, there's incentives for multifamily housing. You know, and the incentives, you can apply for, you know, for example, senior living, and there are certain size requirements per unit for senior living as it is an incentive category within certain zoning districts right now in the code. So this isn't the first time we would be limiting something of this nature. We've done it before in the code.
Then I guess
there a difference? I'm sorry, one just on the same point.
Oh, yeah, go ahead.
Is there a difference? You're saying, so, you know, somebody who comes in and buys the property, buys it with the current zoning, but how about people who currently own their property? Could they come in easier asking for that variance?
Well, the factor of self-created hardship is only one factor. So it would certainly be different from someone who owns a property now and didn't buy it knowing that it was because you've changed it on them. But then it also becomes a question of what would the zoning had permitted previously before you rezoned it. So are they actually getting a benefit because you're allowing increased unit counts? So yes, there certainly is a difference, but that doesn't mean it automatically, in my mind, it's not a significant factor that weighs towards granting an area variance, especially considering the other 4 factors.
Okay.
I guess to look at this from a different perspective, though, I understand our interest and the community's interest in ensuring that we get the unit mix that we've studied under the DGEIS. And I feel like, you know, when we think about codifying that, when we think about regulating that and baking it into our code, I support that. And at the same time, I think we just need to be mindful of making sure that anything that we're enshrining in our code isn't going to have a negative impact insofar as we won't see any development because the property owners and the development community don't want to build the thing that we've said that we want them to build. And so, you know, this question that, you know, this analysis that our experts did to come up with that mix based on looking at other transit-oriented development in you know, similar municipalities, I think we just have to make doubly sure then that we feel confident that we are asking for a product that that people actually want to build, because, you know, my great fear is that we become overly restrictive, and then we ultimately don't see anything new happen in the community at all as a result.
And so I think there's a couple things that can help address that, Ivy. And we talked about looking at size of development as kind of an indicator, right? Because if you have a small 20,000 square foot lot, right, and the max that they can have is 6 apartments, and the size range in the apartments can meet with the directive of the code is one thing as compared to a much larger, entire block development. So there's a difference there. And, we have the ability to look at the different size lots and try and make some determinations to give the flexibility, but also maintain the control. But also let me say this, I still stand by the word, the comprehensive plan, which identifies types in town. We are a mono housing type right now of single family homes. The directive of not wanting to replace or take away from the single family homes, but to provide differing housing types. I'm going to say that with caveat and one caveat only. The COVID experience has questioned what those size of units should be. Not the bedroom count, but the overall size of the unit. And, so I would say the size is a great factor to incorporate into the code, but we need to re-examine that in light of real usable space for, example, a studio. At most, we would probably have 1 adult. But a 1 bedroom, you could have up to 2 adults, and it has to be of an adequate size for people to live in. And that is something that I would be very interested in making sure that we are sized accordingly, but not by increasing the bedroom count. So.
Can you talk though so just using example of when I, lived in New York City and I had an apartment and I ended up having kids and put up walls in my apartment and created a 3-bedroom out of what was a 1-bedroom. Like, can people do that?
No.
Why?
Well, for all the reasons that Nick explained. Nick, I don't know if you want to add to that under the different question.
Do you mind just repeating the question? I was taking some notes.
Well, no, I was just saying realistically, if someone really wanted to take advantage, they could get a 1-bedroom and put up, temporary walls within and turn a 1-bedroom into a 3-bedroom or turn a 3-bedroom into a 4-bedroom or 5-bedroom, depending on.
They could, and someone can build a deck without a permit and extend their drive without permits and finish the basement without a permit. And so we have ways to enforce it. We can't prevent people from going
I'm playing
against the
devil's
law.
advocate here, just to,
No, I appreciate that, but I think there are ways to capture those to the best of our ability. I mean, hopefully we're not playing whack-a-mole with people trying to come ways around it, but there are ways to address this. And if you have a developer, they're not, and these are rental programs, or even if they're owned, you're not going to want to. And it's an annual inspection, we're going to catch them. And there's probably going to be neighbors who are going to report them and express concerns.
Do we generally have an issue with over occupancy of like condo multifamily housing in town?
No. Not at all.
Nick, I mean, that actually, it's a great question to ask. I think, Lori, did you just ask that? I can't see on the screen, but if it's not happening now in the district, what's the reason to expect that it's going to happen more so in the future? But Nick, it seems to me in part, I don't want to say a straw man argument, but anybody can sue, no matter whether it's legitimate or not. So that always can happen.
Right.
But it just strikes me as, from a practical, economical standpoint, to fear that a developer, as you will, as opposed to a current landowner, but even may not have the right anyway, is going to come into town, buy multiple properties to make it worth his or her time to build a big project, knowing full well that he or she can't have 3-bedroom apartments, and then is going to say, I'm going to bog this down in some quagmire of litigation and fighting all these boards and spend more time and money to litigate so that I can have 3-bedroom apartments as opposed to 2-bedroom apartments. So I don't know how reasonable of an argument is. So I ask you, generally speaking, in your experience, have you had scenarios that you're familiar with personally where there have been these large-scale developers, development, buying a property, whatever it may be, knowing a zone, knowing a code, having a final environmental impact statement, and then turning around and suing and doing it successfully to change, for example, bedroom count?
Yeah. A couple of thoughts and responses to that, Jeremy. First off, is that the legislative body has absolute discretion in granting in determining what its zoning is, and so as long as there is a rational basis and it's supported in the record as to why you're doing what you're doing, that will be upheld by the courts. So in terms of challenging the underlying zoning, town board determines what the zoning is, and that's really the one area of land use where you have the absolute rights, as opposed to site plan approval or subdivisions where there are standards that you need to apply. So if it's in your determination, your legislative discretion, that you believe there should not be 3 bedrooms, or you believe there should be the type of ratio or mixture that we've discussed, that can they challenge it? Sure, anyone can sue. Will they be successful? No, because you have that discretion. You have the right to determine what vision you have for your community, and that's what you're elected to do. So you have that absolute right. So let's take it to the next step. They don't challenge the law because they recognize it's a solid law, it's well-founded, and no one can say you've not taken a hard look at the issues, given you've held 5 hearings, you've had hundreds of comments, we've discussed these issues, you're going to have more discussion. So very confident that the legislation you enact will be upheld based upon your great grant of legislative discretion. The question then becomes, if someone were to try to seek a variance, they would have a tough time, because they're coming up against the record. They have to go through the criteria that we've just explored, and it would be virtually impossible to be successful in that scenario. Now, we've represented a number of municipalities. Putting me on the spot, I can think of one example when we represented the village of Sleepy Hollow. There was the redevelopment of the GM site, and the applicant there wanted a greater number of units than were ultimately approved by the board, and Article 78 was filed by the developer. I don't recall if it was restricted by unit counts. It was probably 8 years ago or more, but we were successful in that Article 78 in defending the municipality's denial of the additional units that the developer sought in that case. And again, it came down.
Property, or did he come in and buy it after the fact?
It was a GM site, so he was a contract vendee. At some point, I think they may have purchased it in that process, because you recall GM went through the bankruptcy. I just don't recall the specifics, but they did not own it at the time. They were a contract vendee, and they were coming in. They were not a prior owner of it. And yeah, we made the record. And a lot of these Article 78s, a lot of challenges to a variance, to a granting of the subdivision, granting of a site plan, granting of variances. It rises or falls on the record that you make. And in this case, with the DGIS, you've got a very good record as to what the intent is and why you're making the decisions you're making, whatever they ultimately become.
I have a question that's a little divergence from the bedroom question, but so I can hold it if you want. So I'll just go ahead. So
yep.
I'm wondering about area variances. It might pertain to an architectural style that's not currently defined in the DGEIS as, within the list of acceptable architectural styles. If there were, an architect that had come up with some exquisite design for a building that didn't fall into those categories, how would that be addressed, and would it have the same hurdles as some of the other area variance topics that we're discussing? It
would be treated as an area variance. If I were advising that developer, I would actually go ahead and ask the town board to make a legislative change to relax the architecture standards, and I would then have to go to the town board and justify why they should do so. Because remember, this is a piece of legislation. You always have the ability to adopt a local law and make tweaks to it, and I expect you will. There's no community where we've represented where you adopt a broad changes that you have that you don't come back, whether it's 6 months, 9 months, 2 years, because you're making tweaks, because you're learning as it goes along, and you want to improve upon it and react to what's brought to you. So there are 2 ways in those cases it would be addressed.
But I would also like to say too, the consultant team represented, with the exception of contemporary, that there was a really good cross-section of architectural types that are consistent with what's in the town today, other towns and kind of hamlet villages that we looked at during the planning process. The Architectural Review Board is meeting and discussing the architectural standards some really good comments which will come to you, which I definitely think that there will be some changes to broaden, but at the same time keep some level of restriction of the architectural standards in the draft code. So I think that there will be enough to choose from. And typically, I think in speaking with the consultant who drafted those architectural standards, it would be highly unlikely that we would get a building that would not fall within or among those categories that are in draft code today, with the exception of the contemporary arm, which is very difficult to put standards around. But, you know, from what I have discussed with the Architectural Review Board and others who have commented, we may want to add that as a style with certain flexibility, if you will. But we can get into more of those changes as we move through the FGEIS process.
So if I may, I'm going to actually interrupt here because we've been on this topic for a while and we have a number of things we want to get through in our work session and a brief board meeting before we have to jump off at 7:15 for the Holocaust Remembrance Day event. Does anybody have any further questions on the bedroom issue? If not, I think, you know, then the next steps here, as I understand them, are that we are going to present this information back to our professional consultants who will, I guess, be working with you, Sabrina, on taking a closer look at these available options and coming back to the town board with some additional information on how we can then best regulate through the form-based code. Coming up with the mix of bedrooms and units that we would like to see. Okay. I'm actually going to skip over the next item on the agenda, which was the land surveying, and just move to, in the interest of time, we'll do next 54 Hunts Place, the special use permit for the Conifer building. Jill, do we?
Bob, are you on?
Yes. Good evening,
Mr.
everyone.
Sealy is here. Hi. Okay. Bob, I understand that we have received a request from Conifer for an extension of their special use permit for another 18 months. And I'm wondering if you might be able to give us an overview as to where this project is at the moment.
Yes, basically I prepared a memo, which hopefully everyone has in front of them, dated January 20th, 2021. And basically it compiles all of the information that's required by Tom DePaul, the building inspector, Bart Carey, the Commissioner of Public Works, and myself, the town engineer. And what I did was, just for everyone's information, I highlighted the areas that are 100% complete, but it looks a lot worse than really what it means, because a lot of these items that are not yellowed out to be complete are in the works. And we really don't sign off on things until they're 100% complete. So basically, I don't know if you want me to go through all 50 conditions, but I
How
think
about just highlighting the most important ones, health and safety issues?
well, in my experience in dealing with these projects, the things that can delay the project, and I'm sure Mr. Puglisi can agree with me on this, is the third-party sign-offs that we require from New York State DOT, Westchester County Department of Health, with the RPZ valves and the sign-off for the permits for the work they have to do out there on Quaker Street, Route 120, and some of the work they have to do along the sawmill. Those are the items that could be outstanding. Another items that sometimes take a little bit of time are the maintenance agreements that we need along Hunts Place for the sidewalk, and the stormwater agreement and the maintenance bond for that, which needs town board approval. And I have been working with Jennifer Linton on that, who works with Conifer LaChase, and that's been going strong. But I can really speak for my items really alone. A lot of the items that I do have, basically from 49 to 63, have been looked at and been submitted by Mr. Puglisi, who's on the call, obviously. And I think they're making good progress on this project. And I think it's, speaking to Tom DePaul, they're looking to move in and get everything done, I would believe, within the next 2 months. And based on my take of what they submitted so far. It appears to me they're on track with that, if that helps with town board.
Are there items that are unfinished at this point that involve the town's operations? There's a water main or something like that. What can you speak on that?
The water main that is proposed for the bridge that Jerry and Bart worked on, that's going along the east side of the building. Is that where you're speaking of, Jill?
I think so. Is there some work that the town needs to have done that is not yet finished as well?
No, the only thing that has to be done, as you know, like I just discussed, the town did work with Conifer Chase to do an approved plan, which I think is before the county right now, to extend the water main from the intersection of Joan Corwin Way down along the east side of the building and under the bridge.
Right.
That has not been done yet, but we will work with them to give them a TCO on that condition. Mr. Puglisi can probably speak on that too as well. And I've been working with Bart on that. And that's the only thing that the town did not complete as of yet. But we will allow them to do some work in there from a TCO fashion until such time that's approved by the county and put in probably, I would think, next year, this year. That's
So
the
I
only thing
think,
that.
I think that, I'm sorry, I didn't mean to cut you off. I think the board was questioning as to why another 18 months was appropriate in this particular instance, when you just spoke of, 2 months moving in, that, there would be a TCO involved for some longer things. Mr. Puglisi, can you speak to that perhaps?
In all honesty, I mean, this project has gone on for a while, as everyone knows, and that's our last submission was for 18 months. And I think we just repeated our request for an extension. So we don't necessarily need 18 months though. We don't need 18 months.
Okay.
So do we think if we,
Then why'd you ask for 18 months?
As I said, that's a fault on our part. We submitted basically what was submitted last time, identically, which was an 18.
Okay, so what do you want then? If you don't want 18 months, you want us to approve this, I think tonight, right? So what, how long do you need?
I mean, again, some of the conditions are going to depend on what the town allows us to have for TCO, but I mean, I think 4 months would probably be sufficient. And it'll probably be done before that, but just so we don't have to come back in 2 months if we're not where we want to be.
Bob, you think 2 months is reasonable? Bob, are you frozen? I think Bob's frozen.
Oh, okay. I think 4 months is reasonable. I mean, keep in mind, some of the items they have to do on the parking lot and the striping is weather dependent.
Yeah.
So, if the weather doesn't break when we think it's going to break, and you know how the weather can be, that would delay the project. And they have to do quite a bit of striping in the parking lot, out along the intersection, and up along Hunt's Place as well. So that's something that could delay the project. So, I think just to be conservative, I would recommend 4 to 6 months. Just to be conservative. These, a lot of times in my experience with these construction schedules, they're so very overly optimistic, and something always comes to be, especially when you're dealing, and Jill can chime in on that, especially when you're dealing with third party, when you're looking for something from the state.
Oh yeah,
we
know.
I would go so far as to think about looking at the seasonality and going into, September, October, just to be on the safe side. I mean, with the weather events, the extreme weather events we've had in the past, it's better to err.
Why are we asking for?
Yeah, I mean, they're only
4 months.
Yeah, Mr. Puglisi actually thinks he can get it done in 2. We were giving him 6. I think.
I think 4 sounds generous if you think you'll be done in 2 and you said should be done.
Well, we're not going to be fully done in 2. I'm talking about occupying a building in 2 months and having interior construction done. I mean, there's landscaping items that we're not going to be able to do.
Yeah, I think 6 months.
I don't want to give them more than they're asking for, but on the other hand, I don't want to waste everybody's time by calling everybody back in here in 2 months or 4 months. I mean, 6 months.
I think 6 months is reasonable.
And Bob, just for our own edification, you've been involved in other projects where there's been continued extensions, along the line that things aren't done, and this is not atypical. This request.
That's correct. Yeah, I mean, we have extensions. Sabrina can chime in on this. We have extensions come before the planning board all the time. So, you know, if worst case scenario and they don't have something done, I mean, you could extend it another 6 months if the board wants to do that. And that's generally how we work it with the planning board quite a bit. Sabrina can chime in on that. So.
Yeah, a 6-month extension is not unusual. What they're asking for is not unusual given the circumstances of everything that's gone on at all. And if they need to come back for another 6 months, it's also not unusual.
And during this time, eventually you're going to get the TCO so that people can move in?
No.
Well, really that question is something up for discussion that we'd have to discuss internally with Thomas DePaul, the building inspector, because let's be honest, he's the one who signs it. So, but you know, we're willing to work with Conifer LaChase as much as we can, and that's something we have to discuss with Tom. But we've done that in the past on, in particular, commercial developments.
Didn't we do a TCO at Chapel Crossing? Or am I
Yes,
mistaken?
yes, you did. Those were extenuating circumstances. That was the first time we had ever done a TCO.
Mm-hmm. We've done a TCO with 91 South Bedford as well.
And that came after Chapel Crossing, and most of that is for planting and soft items.
Right. So
if there's good reasons for it, the building inspector is pretty good to work with them on that, but he makes the final call. I cannot speak for Thomas.
Yeah, it's his call.
It's his call.
So are we saying 6 months are on the side of caution, so we don't have to be back here in 3 or 4 months? Is that the agreement?
And that'll pull us out to July, so any planting seasonal issues should be plenty of time to do that.
That is correct.
Okay, that's great.
That was a question, not a statement. I wonder if that's what our agreement is.
Well, that was my.
I'm
that
good
was
with 6.
Yeah.
Okay.
Okay.
There was some public comment on this matter. I see Ed Phillips has joined us.
I can address the letter that the board received from Ed Frank, which raises a couple of familiar issues. I'll just put a period at the end of the last discussion. I was going to chime in, but I think the 6 month, if that's the board's consensus, the 6 month extension makes sense, because I just want to make it clear that the finish line here in terms of the special permit is not TCO, it's not substantial completion, it's completion of all required improvements. So those earlier milestones will not get them over the finish line in terms of that town code provision. And therefore, I think 6 months is probably advisable. I can speak to the issues in Mr. Frank's letter. You know, again, these are not new issues. One has to do with the width of the opening on the parapet on the bridge. It's about 6 feet in width. There was a concern that it raised 2 or 3 years ago about the risk that a car might jump the curb there, turn itself perpendicular to the opening and find its way through, a small car. And I have brought that to Tom's attention earlier today, this afternoon, and Tom's of the same view that the risk of that happening approaches zero, and that the safety measures that are in place at the opening now, bless you, with respect to the opening, really just to keep people from falling through the open space, that it's not designed to stop a car, and there's not a need to have a physical barrier there that would have that kind of ability to stop a moving car. The other issue was the closure of Hunt's Place. And I don't think I'll be able to describe this, but we're talking about the small little nub of a street that is on the east side of that 4-way intersection. And Chief Ferry actually looked at this when it was first raised and concluded that the street hadn't been closed. Hadn't been closed because there's that little extension of pavement doesn't go anywhere. Years ago, before there was a bridge there, it used to go backs. It used to be a grade crossing, but that's long gone. So that was the chief's determination. I don't think there's any need to revisit that. So unless the board had other questions, I can address that. I think covers it.
Thank you, Ed. I appreciate that. The board have anything else for Ed? Okay.
Not for Ed. I just thought, while we had Mr. Puglisi with us, if I could just ask you about the status of the lottery and when you thought folks might start to occupy the building, if there's a
Yeah,
time.
can we actually invite Betty Perry in? She's on the attendee list. I think she was supposed to be on the panel list, or can I do that from my computer?
Pam, is it possible?
I can do that. Yep,
Yeah,
let me do that.
Okay.
I don't have the power.
Yeah.
I have some power, but not that power.
She's in now. She can unmute herself.
Okay.
Okay, thank you. I did unmute myself.
Hi, Betty.
Can you hear me, Chris?
Yep.
Okay, cool.
So we were just hoping that we might be able to get from you an update with regard to the lottery process and when you thought folks might start moving into the building.
Okay, so the lottery is confirmed with HCR approval for March 1st. We are hoping to start the applicant interview process, probably within 10 days of the lottery, because we do have to, go through all the applications. We have to sort the wait list. We have to then pull out those that are not income eligible. So there's
Betty?
She's back. There she is. Yeah.
okay. So I disappeared for a little while. So then we'll start the applicant interviewing, and we hope to start having people start occupying the units starting in April 1st. Our goal is to have it completed. It's an aggressive goal, but our goal is to have it fully occupied by April 30th.
That's great. Thank you. That's literally all I wanted to know with regard to that. I get a lot of questions from people about when people are going to start moving in there. So,
Okay.
And to the extent that changes, if we can just kind of stay in touch about that, people are very excited for new residents to come into our community, and we're looking forward to welcoming people. So that's great.
Excellent.
Anybody else on the board? Questions? Okay.
All right. Going to try to go into overdrive then. Mr. Puglisi, thanks very much for joining us. Ms. Perry, thank you.
Oh, thank you.
Thank you.
Okay. The next item on our agenda is authorization to remit payment to Con Ed. So this has to do with our Millwood Park lighting improvement project. In order for us to obtain upgraded electrical service for the new lights that are going in on the Millwood field, Con Ed had to do some major layouts and designs. The corresponding plan is just shy, sorry, not plans, the plan is just shy of $20,000. This was an anticipated cost as part of the capital improvements. Bob's here to answer whatever questions the board may have about it, but I think the bill started at $40,000. We were able to get them to $20,000, but I don't think we were able to get them down any farther than that.
I'm just going to say goodnight to everybody.
Night, Sabrina.
Miss
Thanks
Sabrina.
very much. Any other questions for Bob? Any questions for Bob on this? Okay, great. Thank you. The next thing on the agenda is the Amsterdam Park security. As the board may recall, in the spring of last year, Amsterdam Park was vandalized. Someone with an all-terrain vehicle entered our fields and ripped up our soccer fields and really did substantial damage to them. In addition, there has been vandalism from time to time in our playground. We realize that we need some security out there, and we have done our due diligence. We've had a little trouble locating companies, ascertaining bids from companies that would consider our project. We have secured a bid from one company, Simon Securities. The details of it have been provided in your packet. We would like to proceed with a hybrid system at a cost of $95,074 to try to see what security would look like out at Amsterdam. We think it's a
9,000, Jill. 9,500? Not
I'm sorry.
95,000, right?
Gosh, did I say thousands?
Okay.
I'm trying to read quickly. I apologize. Oh my gosh, $9,574. No, way too much money. So under $10,000. The chief has reviewed the plan, as has Bart and Ike. They're very excited to try to get a security system out there, have it operational, and if we're successful with that, be able to extend it to our other parks as well.
It would be nice to get some reduced, you know, to realize some savings if we're successful with this and we decide to put it in some additional locations. So, you know, if it's 9,500 for our first location, it would be nice to see, you know, reduced costs at those future locations. I mean, if we could even lock them into what that pricing would look like now, that would be good.
Yeah, I just we're hopeful that it's going to do what it promises to do. So, you know, combination of Wi-Fi and hardwired, and it's overdue, unfortunately. We will talk to them.
Do we have a list of what those future locations might be?
Yes. So we have Gedney Park, Glacier, Whippoorwill. Our parks also, there's potential for upgrades at our train station, and the actual building, and then at the exits at Washington Avenue and the entrances at Woodburn and Lower King. So we'd like to, we've got a laundry list of things, if this works well, that we'd be able to expand to. So we'll certainly speak to Simon Securities about that. We have great hopes for them. So the next thing I'd like to talk to the board about is the water notices. So council has informed us that part of the governor's executive orders requires the town to give notice to residents if they have been financially affected by COVID-19 and are unable to pay their water bills. That number one, an installment plan is available to them, and that the town cannot shut their water for 18 months beyond the duration of this executive order, which expires on March 31st of 21. It is not the town's practice to shut water. There was one case that I'm aware of in the last 25 years that was a bit of an odd situation, but basically that's the only situation where we've ever shut the water. We have included in here the notice that we intend to send out. It will start going out in water bills, and I just wanted the board to take a look at it before it went out. So if you can just take a look at this and make sure that you know, it meets with your approval. The next thing on the agenda is authorization to issue an RFP for land surveying services. This would be our first step in trying to finalize the plans for the parking lot in front of Town Hall. The configuration that is currently in front of Town Hall was an in-house attempt to maximize our parking potential when we had construction in the back of Town Hall and didn't have use of the Town Hall, the rear parking lot. It was never intended to remain that way. We have a professionally laid out parking plan by Barton and LaJudas, who is the firm that took and designed our basketball court and our playground, because they understood that we had lost significant parking in the back of the parking lot. And this was our attempt to recoup some of it and make it easier for residents to be able to patronize Town Hall by giving them a convenient parking spot. We would just like permission to go out to issue an RFP, a request for proposals, to actually try to secure a landscape architect. And we will have further discussions on what that layout looks like before we actually have the landscape architect go out and actually lay out the plans for us.
Just to be clear, the further discussions that we're talking about are not internal discussions. We intend to engage the neighbors in this conversation.
Right.
Oh, Sheila, excuse me.
Yes.
That's actually for the RFP to get land surveying services.
Yes.
For the line and grade.
Right.
So.
Thank you. And last but not least, I had our parking permit season for 2020-2021 actually started on December 15th. And it's been a very slow, painful rollout. And one of the things that I wanted to pose to the board was a rolling grace period. Because we don't have a huge number of commuters, regular commuters, and because our traditional advertising methods of putting the big sign in the circle at the train station where the farmer's market is and people drive in during the day and can see it. One of the challenges of having a winter start time and of our parking permit season is then when we advertise that parking permits would take and renew, people are arriving at the train station in the dark, they're leaving the train station in the dark, and they're not seeing a lot of our usual advertisements. So what I'd like to propose to the board is that we offer a grace period to our commuters so that if you get a ticket for parking in the train station without a permit, that we would give you 7 to 10 days, and it would be to the board's discretion, to take an issue to obtain a commuter parking permit. And we would waive the ticket if in fact once you got it, you went in, you got your permit, you can renew online, you don't even have to go into the office. And we would take and waive that without you having to go to court. And that way, instead of the traditional grace periods that we used to give people when the parking permit season started on June 15th, we would wait until July 1st before we took and we enforced. This way it would be rolling as people start return to work with vaccines being administered, that if you got caught and didn't realize that the new parking season had started, that we would offer this rolling grace period to people. As of this point, we have almost 500 people that have applied for permits between our annual permits and our daily meter permits. There were 27 tickets issued the other day that I think caught people by surprise. We have 3 people who actually paid, but we haven't deposited their checks yet. So we're going to take and reach out to them. We won't be depositing those checks. So we'd like to be able to offer this. And we have a number of people who I believe got permits, but then submitted not guilty pleas to the court because they were going to take and argue their case. Yes.
Do we have a mechanism to dismiss the ticket if folks renew their permit online?
We do, because we know the people that have actually gotten tickets and we know the people that have renewed, but we're going to put a blurb. If the board agrees that this is the path they'd like to take, we would put a blurb in our newsletter, and we would be able to reach out to people. We would
you just be cross-checking any renewals that came in against any tickets that were issued.
Right. And with the resolution, Nick tells me that the town clerk's office would be able to then take and dismiss the tickets without you having to go to court, which is an issue that we've had before where, the town clerk's office can't dismiss the tickets. It would have to go to justice court and before the court. Am I correct, Nick? That's something that we could do internally without involving the justice court and requiring an appearance? You're on mute.
No, most people like it when I'm on mute, but yes. Yes, we would have a town board resolution authorizing the withdrawal of those tickets that would then withdraw it from the justice court.
And that way we wouldn't have to burden people with actually having to go into justice.
Yes. Generous and creative solution that you've come up with. And I'm really grateful to you and to everybody who worked on this solution. I feel like it's another example of our team at Town Hall just sort of going above and beyond to really try to accommodate people during this crisis. And so I'm really grateful to you, Jill, for coming up with this. I think it's great.
Not a problem. Okay, so we'll take and prepare that resolution and we'll have it ready for next week. Okay.
And Jill, I'm sorry, are we code reading this, or are we just?
Yes, well, we will. What we're going to do is we're going to code red that the parking permits are, season has started, yeah, we'll put it out on the electronic board. We'll put it in our e-newsletter along with a little blurb saying that, this is our intention, that, if you get your ticket and you come right in and you renew online, we will waive the ticket for you. Just, let us know. Okay. All right, we're not out to trip anybody up. We're just trying to, get back on track. I was going to say that's not my dog. We just have a couple of administrative items. I'm hoping my watch is a little fast. Thank goodness it is. Okay. We have a National Gun Violence Survival Week proclamation, adoption of minutes, and authorization to go out to bid for the 2021 T-shirt contract. This is for Parks and DPW. They have the T-shirts is part of their, and also camp shirts, but the T-shirts for staff is part of the union contract. Authorization to purchase a vehicle from Recreation and Parks. This is something that is included in our budget from the 2021 budget. Authorization to reimburse building permit fees. There's 3 of them, and also authorization to purchase water materials for DPW as part of the Millwood Water Treatment Plant requires. That's all I have. And then moving on to a very quick board meeting.
Okay. Move to adjourn.
Any questions? No. Okay.
Nope. Second? Or do we have
All in
to?
favor?
Okay. Aye.
Okay.
Okay. Welcome to the town board meeting for Tuesday, January 26, 2021. We have a very brief meeting this evening. I will actually hold over the supervisor's report and we'll put it out in tomorrow's e-newsletter. The only announcement that I wanted to make is to encourage everyone to please join us immediately following this for the International Holocaust Remembrance Day event, which is being co-sponsored by the Horace Greeley Enough Club and the Town of Newcastle Holocaust and Human Rights Committee. So 7:30 that starts. Jill, administrator's report?
I will hold it. I know that Jeremy just wanted to mention the survey.
Correct.
You're talking about the survey for the police reform?
Yes.
Yes. So we do have a survey that we worked with. In fact, the CRE helped kick it off, and it was a big product of it that went through the reform committee, which is from the governor's executive order that we're all looking at local municipalities and our police force, which probably many people know already. And there will be a survey that's going to be sent out, which basically gives residents the opportunity to answer some questions about their experiences here in Newcastle. Additionally, there'll be some statistical information which you can or cannot provide. It's up to you about your background, how you identify, your gender, your racial background, ethnicity, so that we can really get down to the nuts and bolts and see how we can deal with certain issues here in Newcastle. And then some of that will be used locally, as well as some of that will be used, I presume, shared beyond. So thank you to Jill, really, who spearheaded this with people from the CRE. Herman Charles was involved as well. So thank you, everybody, but that should be going out.
And you can actually just find the link to the survey right off of our homepage. It's in the banner right up at the top, and we'll have the information in the newsletter tomorrow. Thanks. Okay, can we, before we move to the resolutions, an opportunity for public comment and new business. Do we have anyone who would like to make a comment? Okay, we have one person with their hand raised, Suzanne Chazen.
Suzanne, you can unmute yourself.
Hi, I know you're busy. I know that you're trying to get out, but I just had a question, sort of a general question at this point. I have not seen anything since October 16, 2020 in any of your forms about the total cost to Kimley Horn, Torty Gallus, Res Group, Joel Russell. I know that on 42319, that amount to paying for all the form-based code was just shy of $400,000. I know that there was a piece of paper, Amendment 3 on October 16th, that was left blank, and I have not seen any costs since. And I would really like if the town board would give residents an accounting for, at this point, how much everything has cost.
Okay.
We can provide that information. I don't have the numbers in front of me this evening as it wasn't on our agenda, but we can certainly provide information as to how much has been spent. There have been no additional expenditures in recent weeks on the form-based code. If there were, they would have appeared in the public.
Can I just ask, does that mean that when the planners come and look at the public comments, that they aren't going to charge additional, or does that just mean that that clock will start ticking when they start doing that? I'm sorry, my question wasn't clear?
No, your question was clear. Jill, you opened your mouth. I wasn't sure.
I didn't quite actually understand it. Everything that we've done so far is within the scope of the contract.
So when the planners answer all the comments that have come in, that's still under the scope of the $400,000. There's no additional cost?
As of this point, the board has not approved any additional cost. And just so that you're aware, we approve payment of claims almost every meeting. That is a detailed list of the bills that the town pays. So there shouldn't be any mystery as to what the town is paying.
I just haven't seen anything, and I'd really love to know that. So if you could make that, if I'm not aware of it, probably a lot of other residents aren't. So maybe if you can make it clear that there haven't been any additional costs, or if there have been, if you can make that clear too, that would be
I'm
great.
making that clear right now. There haven't been any additional costs. If there had been, it would have been on the agenda and you would have seen it. But we can certainly put together a full accounting of all of the monies that have been spent on the form-based code today.
Thank you.
Requested.
And Jill, if I could just add, and money to a certain extent is fungible, meaning, money can be moved around to different places. But one of the things that the town had received years ago was $1.5 million for Summit Greenfield, in part for, there was discussions about, Trailway, the discussion about improving the downtown. So while it's not $1.5 million now, that money is been used to enhance the hamlet, to enhance the relationship between Chapel Crossing and the downtown. So it was set aside for that purpose. So it's not as if we're saying we're going to raise your taxes to pay for something that you may or may not support, but there is a pot of money that's obviously dwindled over time because it's being used for the purpose of enhancing the municipality and the hamlet.
Yes.
Yeah, we have one more comment that we'll take. Marianne O'Connor, please.
Hi, thank you. Just to follow up on Suzanne's question, I think the answer seemed to be with respect to services already provided. But just to be clear, do you have projections of the future costs, the estimates of the hours and costs for the consultants to provide responses to all the various substantive comments that have been and continue to be provided on the DGEIS? So if that work hasn't started yet, what is the projected cost for that future work? Are they giving the town board an estimate of those future charges? And what is that?
No, that work is covered under the base contract for the form-based code. If they determine that there's additional work that's needed that's outside of the scope, then yes, we would anticipate them coming back to us with estimates. But at this time, we have received no requests of that nature. But keep in mind, the public hearing is still open. So the further analyses and the work on the final generic environmental impact statement have not begun yet.
Resolutions?
Yep.
Terrific.
All right, I move to adopt the January 12th, 2021 Town Board minutes and January 19th, 2021 work session minutes.
Second.
All in favor?
Aye.
Aye.
I move to adopt the following resolution. Be it resolved that the town board of the town of Newcastle adopts the attached town board consent agenda policy. And this was previously discussed at a prior work session.
All in favor?
Aye.
Aye.
I move to authorize issuance of a bid for the refuse and recycling contract.
Second.
All in favor?
Aye.
I move to authorize issuance of a request for proposal for graphic design services for the town.
Second.
All in favor?
Aye.
Aye. I move to authorize the renewal of the annual system support agreement with NIC Systems Support Corporation for the Millwood Water Treatment Plant control system for the total cost of $9,750, which includes telephone support, an annual cost of $2,500, and on-site support at an annual cost of $7,250.
Second.
All in favor?
Aye.
Aye.
I move to authorize the appointment of Bart Carey to the position of Commissioner of Public Works within the Department of Public Works at the annual salary of $160,017, along with the assignment of town vehicle for after-hour emergencies effective retroactively to January 1st, 2021.
Second.
All in favor?
Aye. This was a revised resolution. I apologize. We had left out some key information the first time around.
And he's taking Jared Morshell's place.
Right.
Yay, welcome,
Yay.
Bart.
I move to authorize the promotion of Thomas Costello Jr. to the position of Assistant Commissioner of Public Works within the Department of Public Works at annual salary of $142,500, along with the assignment of a town vehicle for after-hours emergencies effective February 1st, 2021.
Second.
All in favor?
Aye.
Aye.
Welcome, Tom.
He's taking Bart's place.
I move to authorize the posting and hiring for the position of Assistant General Foreman within the Department of Public Works.
Second.
All in favor?
Aye.
Aye.
I move to authorize the hiring of Leah Bick for the position of Recreation Attendant within the Recreation and Parks Department to serve as an Art Center Assistant at the hourly rate of $14 per hour effective January 27th, 2021.
Second.
All in favor?
Aye.
Aye. I move to authorize the issuance of an RFP for land surveying services for the front parking lot located at Town Hall, 200 South Greeley Avenue in Chappaqua.
Second.
All in favor?
Aye.
Aye. I move to authorize the payment to Con Edison for the installation of a new pole at 245 Sawmill River Road for a total cost of $19,831.90, which is required for the Millwood Park Lighting Improvement Project.
Second.
All in favor?
Aye.
I move to authorize the Recreation and Parks Department to go out to bid for the 2021 t-shirt contract, which includes t-shirts for DPW and park staff, as well as various recreation programs.
Second.
All in favor?
Aye.
Aye.
I move to authorize the purchase of a 2021 Ford 150 4x4 regular cab pickup truck and equipment for the Recreation and Parks Department from Carmody Ford, 1111 State Road 29, Greenwich, New York, for a total amount of $30,638.
Second.
All in favor?
Aye.
Aye.
I move to authorize the issuance of a 100% refund of the full application fee for building permit number 19591 due to the property being mostly in Mount Kisco for a total amount of $295 to Greenwich Power Systems, 209 River Road Extension, Coscob, Connecticut.
Second.
All in favor?
Aye.
Aye.
I move to authorize issuance of 100% refund of the plumbing permit 5257 due to an error with the address for a total amount of $85 to Robert M. Spano Plumbing and Heating Incorporated.
Second.
All in favor?
Aye.
Aye.
I move to authorize issuance of a partial refund of electric permit 20-00348 for a total amount of $225 due to an overpayment to T. Weber Plumbing and Heating.
Second.
All in favor?
Aye.
I move to authorize the purchase of a 6-month supply of water treatment chemicals from Millwood Water Treatment Plant at an estimated cost of $42,432.
Second.
All in favor?
Aye.
Aye.
Shall I read this? I know we're short on time, but this is,
Yep.
I'll read this whole thing. I think it's worthy to read.
Mhm.
I move to adopt the following resolution. Whereas every year, nearly 39,000 Americans are killed in acts of gun violence and nearly 85,000 more are shot and wounded. Whereas by early February, more Americans are killed with guns than are killed in our peer countries in the entire calendar year. Whereas a gun violence survivor is anyone who has personally experienced gun violence, whether they have witnessed an act of gun violence, been threatened or wounded with a gun, or had someone they know and cared for wounded or killed. Whereas forms of gun violence can include, but are not limited to, gun suicides, gun homicides, domestic violence involving a gun, shootings by law enforcement, and unintentional shootings. Whereas 58% of American adults, including 68% of Black and Latino Americans, or someone they have cared for, has experienced gun violence in their lifetime, demonstrating the reach and impact gun violence has in communities across America. Whereas firearms are the leading cause of death for children and teens. Whereas Americans and communities across the nation are working to end the senseless violence by advocating for common sense gun safety legislation. Whereas by commemorating National Gun Violence Survivor Week on February 1st to February 7th, cities and towns across America will raise awareness about gun violence and honor the lives stolen by gun violence. And whereas we renew our commitment to reduce gun violence and pledge to do all we can to keep firearms out of the wrong hands and encourage responsible gun ownership to help keep our community safe. Now, therefore, be it resolved that the Newcastle, New York declares February 1st to February 7th, 2021 to be National Gun Violence Survivors Week. We encourage all citizens to support their community's efforts to prevent the tragic effects of gun violence and to honor and value human lives.
Second.
All in favor?
Aye.
Aye.
One last resolution.
Yep.
But Christina sent it around, Conifer.
You got it, Jeremy, or you want me to do it?
I don't have it in front of me, so if you want to take it.
All right, whereas by letter dated January 13, 2021, Conifer LLC requested an 18-month extension of time to complete required improvements at the Chappaqua Station Apartment pursuant to Town Code 60-4430, whereas by a memorandum to the Town Board dated January 15, 2021, the Town Building Inspector recommended that the Town Board grant Conifer's request for an extension of time. Now therefore be it resolved that the Town Board finds that Conifer has been reasonably diligent insofar as completing the project and there are no changed circumstances that would warrant reconsideration of the special permit, but an 18-month extension is unnecessarily long given the status of the project. Therefore, be it further resolved that the time period set forth in Town Code 60-430M as applicable to the project is extended 6 months from the date of the adoption of this resolution until Wednesday, July 28, 2021.
Second.
Isn't it Monday, July
That's Monday.
26,
Yeah.
2021?
No, I changed it to Wednesday so that in the event there should be an extension requested, you have a Tuesday town board meeting to consider it.
Got it. Okay, second.
All in favor?
Aye.
Aye. Okay,
Oh, clever.
can we get a motion to adjourn?
So moved.
Second.
All in favor?
Aye.